Good morning, everyone. Welcome. Thank you so much for joining us here for our session on delivering on children's rights online and improved digital world for all. I don't know if it needs a question mark, but we've put one there anyway, just in case. My name is Leander Barrington-Leach. I'm the Executive Director of the Five Rights Foundation. If you don't know us, we're an international NGO working to build the digital world that children and young people deserve. We work with young people and carry their voice around the world, and on top of that we do research, quite a lot of advocacy and compliance work also. So I am absolutely delighted to organise this session here today because we know what an audience of experts we have, and so we're really looking forward not only to hearing from our panellists but also to hearing from you and to seeing how you are contributing or want to contribute to this work to improve the digital world for our kids but also for us all. So we have an hour and a quarter today, and luckily we have a nice room so no one has to stand and it's not too hot, which is not always to be taken for granted. So we have an hour and a quarter. We are going to hear from our speakers in what is really a moderated conversation. So I'm going to be asking questions and it's going to be rather hopefully dynamic, and we'll come back on a number of points that catch attention, and then hopefully we'll be hearing from you too. The aim really is to leave here today with some practical conclusions and outcomes, and as I say, a commitment and an understanding of how we can move forward together. We are at an important time in this work. I'm sure many of you are aware that the European Commission just released its draft guidelines on Article 28, so that is ensuring a high level of privacy, safety and security for minors under the Digital Services Act. So it's a very exciting time to see how we can take this forward and how we can ensure that finalising, implementing and enforcing this critical piece of law, as well as others such as the GDPR, as well as the AI Act and maybe others, and forthcoming legislation such as the Digital Fairness Act, for instance, how in going forward in all of this we can ensure that it actually delivers meaningful, practical change to the daily experience of children online, and as we say, not only of children, but how we can also demonstrate that it can work. Some things which we're told, that's not possible, that's going to break the internet. I'm sure everyone in this room has been hearing these kind of arguments for a long time. How we can practically prove that change is possible, and then how we can take it further to make sure that it has the widest, biggest societal benefits possible. So that is our aim. Now, I am absolutely delighted to introduce our speakers. I'll start with Lynn from the Norwegian Consumers Council, a long-time partner of the Five Rights Foundation. Here I have Yanis from the Ministry of Digital Technology in Greece. Welcome. And on my right, sorry, I have to look at my hand, I don't know my right or my left. On my right, I have Felix from NOIB, notoriously good at the enforcement work on GDPR in particular. So I think an absolutely excellent panel. And online, we have Ali Hassami from the IEEE, among others. So Ali is our engineering expert, and we could not ask for better. Ali recently has done a lot of work also contributing to this, the Children and AI Design Code, and is really an expert in this area of automated technologies. So with that, I'm just going to start, I think, by a poll. Why not? Because I was asked to set the scene and to introduce a little bit the issues that children are facing online, but I actually think that you are going to be the experts in this area. So I'm going to ask you just to raise your hands, how many of you interact with children on a daily basis as parents, grandparents, brothers, sisters, aunts, uncles, teachers, whatever? Okay, so quite a few, around half of the room. Now, how many of you think that those kids are spending a bit too much time online or they're struggling with their screen use? Okay, quite a lot. I think that's pretty much the same number. So actually, the average time spent online by children in at least in the US and northern or most of Europe is more than 7 hours a day. So that's quite a lot. If you don't consider that a lot, then, well, that's a different story, but that is the average. And maybe, again, because of the people in this room, maybe the kids spend a bit less. I don't know, I hope so. How many of you think that those kids feel themselves that it is a problem, their screen usage? Not nearly so many, which is really, really interesting, because actually, consistently around 50% of children say they feel addicted to the internet. So I think sometimes as adults we might feel, oh, they spend too much time, but maybe it's us. But actually they really, really feel this themselves. Well, can I ask how many of you think that the kids that you're interacting with like struggle to get off or nag to get back on or just can't pay attention and feel like, you know, they always prefer and are asking to be on screens? Okay, that's about the same amount as at the beginning. So I think this is really interesting. Last night I had dinner with a friend who told me that she was a few days ago at the theatre in London watching Mary Poppins, so family musical, lots of music and lights with her 11-year-old, and they were sitting right at the back. And she said she was extremely shocked to see how many iPads and iPhones started lighting up and stay lit up throughout the performance. I think this is fairly typical nowadays that even when engaging in activities that are designed for kids, kids are losing out on those activities while always wanting the preference to go back to the online world. I think if you ask teachers and also university professors about attention problems, it's something that will come up very, very frequently, that kids nowadays find it really difficult to pay attention for more than 5-10 minutes. Writing more than a paragraph is difficult. This kind of very short attention span is something which is maybe not just it's something in the television and things world that we also have experienced, but it's definitely there. How many of you think that the kids that you know have encountered disturbing or age inappropriate content? Yeah, again, about the same number. So indeed, almost every child encounters porn, well before their 10th birthday. Eating disorder content, sexual content. How many of you know that those kids or seriously suspect that they've been contacted by strangers? Yeah, again, most, but actually, yeah. I mean, I don't know about you as adults, but, the same, all of those friend requests, contact me, dodgy links and things, kids get all of that. I could go on. We could talk about bullying. We could talk about payments online or being pushed and nudged to do things like that. But I think it's very, very evident that the vast majority of kids are really struggling with this and that they are exposed to risk all the time and harm very, very frequently. It's considered by them to be just now a normal aspect of daily lives. Of their daily life. Now, what to do about it? Today we're really going to talk about the legislation and what we have and how to take that forward. But I think it's just important before we start to talk about the fact that this is, of course, and again, in this room, if I talk about attention economy, data economy, I think everyone knows what I'm talking about, so I'm not going to go into all of the detail. But we know that this is how the system is designed. This is the system kids are living with, and this is the system as adults we are living with too. So if I ask all of you one last question, how many of you feel like you struggle with your screen time? Oh, my hand's going up everywhere. Oh, yeah. I can imagine, trying to work, trying to concentrate, always being interrupted, hard to put down. So therefore, I think this is why we're here to discuss what we can do for children where we understand that there is a huge, huge public and political will to do something and how we can take that further to benefit also all of us. So I think that is enough for my introduction. Sorry it was so long, but thank you for all of your contributions. I am going to start then by taking a step back, and not back to the challenges, but back to the political and legislative landscape, which, as I said, that's what we're going to address. How can we practically, with what we have on the table, move forward? So I'm going to start with a question to Lynn. Lynn, so protecting the most vulnerable, including as consumers, has been a social priority in Europe for a long, long time. This is not new. We have a lot of tools and laws and experience in this area. Protecting children has also driven a lot of the progress in broader social rights. And here we are, say, struggling to apply these really hard-won protections in the new digital era. So why is this? What are we missing?
Thank you. I think one of the reasons why we struggle so much with children's rights online is really that it's a little bit more hidden. It's unprecedented that sellers and companies can have direct access and communication with children at all times during the day through their phones, through their laptops in schools, as they're playing with their friends or having games alone. So we have a situation where sellers are basically following children all over, like in the streets, but it's on the phone, so it's not as easy to see. And when it's out of sight, I think it's also a little bit out of mind, or it has been. And then in the same way, children actually see different things than adults. So we have children seeing kind of different feeds, they're getting different types of content from what adults are seeing. And that has also kind of helped this issue go a little bit under the radar for 20 years, right? It's been a long time since social media was introduced for children and adults alike. So that is maybe a part of it. And then I think also it's been taking a very, very long time for policymakers to truly understand and kind of put the finger on the fact that these services are designed for profit in a way that is interlinked completely with risks for children. So the ways that companies are making money is also the ways that make the services into something that is risky, into something that is pushing content that is not good for children to see, into something that will push ads on them to make it extremely commercialized, and into something that will create addictive design. So that is kind of the landscape that we're in and have been in for 20 years. So it's really good that we're having this conversation, and I think that policymakers everywhere are having a lot more conversation about what we can do about children's rights online at this time. But that also means that we have a lot of legacy that we need to really work through at this point. So in Norway, for example, where I am based, we have 10 different laws that govern children's rights. And they have different scopes, they have different regulators, they have different kind of opportunities for regulators to impose fines, for instance, for breaches of children's rights. So there's this whole work that has to be done right now to kind of see children's rights holistically and ensure that they are built into the services that children are using every single day for different purposes in their life. And then this kind of, there's an issue in that we need to see children's rights holistically, but this also means that it's really difficult for children and their guardians to know when their rights are actually being breached, because you need to have a law degree to understand what kind of rules apply to children's rights online or children's kind of doings online. And then on top of that, it's really difficult to understand that I mean, unless you actually work in data protection, it's really difficult to see that the fact that children are getting content for kind of like what you should eat and what you shouldn't eat, that can lead to eating disorders, that this is actually deeply interlinked with the fact that the services are personalized and are very much kind of using personal data to target the content. And that is a hard link to make. So you really need to have expertise in law and in technical matters to even understand how we can start tackling the harms that they are seeing online. And so I think a big part of the issue is that all of this has been hidden for a long time. We haven't had enough focus on it, and it's still quite difficult to really realize all of the laws that we have, because it requires so much legal and technical knowledge.
Yeah, indeed. So 10 different laws identified in Norway. I think this is the point, that indeed, as you say, that there's a lot there. It's not that this is, that protecting children in even a commercial environment is something new, but we're still struggling to do it. And we do have, since 2016, a law which is specifically targeting digital service providers, and also is quite a bit about design, so GDPR. Now that is nearly 10 years ago, so Felix, I'm going to turn to you. So GDPR has also, got some provisions for children, and we have got quite a bit of time experience. I'm not sure what the right word would be now in implementing and enforcing GDPR. And there have been significant changes, I think, but there's been a very kind of clear ceiling, and we're still struggling with the same really basic, fundamental business model design issues. So why have we not been seeing further change? That's what GDPR was for.
Well, hi, and thank you for having me here. It's a pleasure. Well, as I understand your question, it's about why is the GDPR, for example, not delivering? Why is there no significant change, right? And yeah, I would argue you're right. There's more visibility, for example, for tech issues. That's why we are all here, and this conference got bigger and bigger over the years. There's new regulation. And of course, yeah, the GDPR has some provisions that relate to children, and seen in a broader context, or as a side note, it also offers extensive protection for everyone in here, also for adults, and that extends, of course, as well to children. So we do have this framework, and yet, from my experience, my personal experience, and my professional experience, there's a real lack of administrative enforcement. So, in other words, the data protection authorities, they're sometimes lagging behind years on their cases, and sometimes it's not only years, they will never decide a case at all. So we, for example, at NOIB, we have cases that we launched in 2018 or 19 that are not decided today. Think about that, that's several years. You could study a law degree in this time. So, just to say, you know. And also, like, ex officio, like when the authorities are just, when they act on their own volition and on their own initiative, that's also something extremely rare. Sometimes it happens, but it's not like a common thing. So this is one of the key issues. I wanted to bring an example today in order to explain that a bit with the context of children. So last year we filed a complaint against Microsoft 365 Education, which is basically the same software as Microsoft 365, but for schools and universities. And by the way, my colleague Marcia, who's not here right now, she worked a lot on this as well, so I wanted to credit her. In any case, so we did a lot of research in order to figure out, so what does this software do, how does it work, and why is everyone fine with using it? And so during our research, we found some guidance from data protection authorities that was actually very interesting. So this guidance said, oh, there's massive data flows from the students' accounts to Microsoft, and not even Microsoft itself could explain to the data protection authority what this kind of data flow was. That's literally what one of the documents of a German DPA says. So they said only 11% of these data flows were reported in the data protection assessment that was done in this moment for using Microsoft 365 in education. So that was one thing where we were like, wow, this is shocking. And the second thing is, then we proceeded and took a look into the data flows ourselves and analyzed them. And we found that on a school kid's account, they were just placing regular Microsoft tracking cookies, which I think is a shame, honestly, because the software is still used across Europe by millions of students, and we don't care, apparently, or not, we don't care enough. And yeah, we know this is public, this information is available, but no enforcement action is taken whatsoever, and there's no improvement to be seen. And from my perspective, and from a legal perspective, I think as well, tracking children in educational software is a complete no-go, but still continues. And some possible reasons for that, well, sometimes it's just easy to maintain the status quo, like to just keep on doing as we've been doing previously. And the other thing is maybe there's some political pressure as well on data protection authorities, maybe also due to a lack of alternatives. We also need to think about, well, how can we improve the situation? How should we improve the situation? And as a society, I think we should strive for compliant solutions, not for convenient solutions. And well, this connects back to the title of this panel. If we cannot even protect the children online properly, how are we supposed to protect ourselves?
Thank you so much, Felix. Indeed, struggling with GDPR enforcement, but hopefully, as you say, we'll learn and do better going forward. I just want to say on the edtech issue, because I think this case is really brilliant. There was a UNESCO report a couple of years ago called the edtech tragedy, which showed, with a global study, showed that there was no evidence of benefits to children from any edtech. I think it is really shocking that there is just this assumption that putting technology into the classroom obviously is going to benefit learning, and there is no evidence behind this. And it really is a tragedy that, as you say, we apparently don't care all that much. So this is something that Five Rights will be working on edtech in particular in the coming years, so you can watch this space. But I'm going to go to Ali. Hi, Ali. Great to have you there online. I'd like to ask you, Ali, for your reaction to what Lynn and Felix have just raised regarding the challenges we faced regulating to date. So do you think that, from an engineering perspective, from a professional perspective, that we need to double down on enforcement, or in the current environment with AI and all this, are we just missing the point?
I wouldn't underplay the role of enforcement. Of course, the legal system is a safety net for the whole community, especially the vulnerable groups such as children. Over the past 10 years or so, I've done some work at IEEE, interestingly, and I've been honored to be involved in this work on ethics of technology. And I find even though the laws are essential in order to prevent and potentially deter serious abuses of one-sided interest by commercial organizations in terms of profit and revenue, I find that we need to also adopt a rather enlightened approach and do two things. First of all, give them credit that they can be ethical should they be shown the way, and then also go about producing the fillers between a free for all type of world without laws to extreme enforcement paradigms where nothing moves unless it's double checked and inspected and verified and authorized. We need to find a medium where the social as well as the commercial enterprises are encouraged to assume responsibility for what they do. And my favorite motto was from shareholder value, transition to social value. So if we manage to encourage these enterprises, we would probably find we don't need to depend as much on stricter enforcement. And to this end, IEEE as a global institution invested a fair amount of energy and time, and I had the honor of architecting the processes for this over the past 10 years, a series of ethical guidelines with smart criteria and metrics. So we were not just asking people to be accountable, responsible, transparent, fair, respect privacy, etc., as the laws do, but we were actually telling them what it means and how to do it. So in that respect, there were also training program and some guidelines produced and published on a pro bono basis, where we basically shared our vision of how to be an ethical enterprise in the game. And of course, again, the ethics would be somewhere between self-regulation and the legal system of hard regulation. So that is frankly where I think the regulating tech needs to go. The other challenge that has not been mentioned, especially with the artificial intelligence, which is the popular topic of CPDP, is the fact that this technology has leaps and bounds and moves in a non-linear fashion, and there are occasional major developments almost happening with an overhang, in the sense of we suddenly are informed that there is a whole new set of realities, functionalities, and breakthroughs. And unfortunately, the legal system, like many other classical institutions, would not catch up with this pace of evolution and change. So that is the other challenge we have to enforce regulation. We would never catch up. It's almost like the vicious circle of crime and punishment, that crime happens first, then we have to chase and apprehend and prove, etc. So it's almost crime, almost one step ahead of enforcement and law. The same applies here. The technology is one step ahead of regulation and is transforming, muting on a fast and unprecedented basis. So going back to the drawing board every time, adding an annex here and another clause to existing regulation, maybe ineffectual, desirable, but ineffectual. So we need to go and find this gap filler to help the tech regulate somehow or be aware of what is it that they should assume as social responsibility, and more or less also practice this, be transparent about it, name and shame the misleading or misbehaving tech organizations, because they care about their reputation that impacts on their bottom line commercial performance. So instead of just doubling down on enforcement and ignoring all other instruments, I would recommend that the missing point here is how else we can bring some measure of social responsibility to technology organizations, public and private. Frankly, it doesn't matter. We have had examples in our work where some social and public organizations were knocking on IEEE's doors and saying, can you help us be more ethical? It's wonderful. This is a really transformation I very much like to see encouraged and promoted in the commercial context.
Thank you so much, Ali. I think, we will all agree with you that that is the world that we want to see with enterprises, both corporate and non-corporate, acting responsibly, caring, about the impact of their products and services. I think the challenge is that, the reason that we're here is that we don't see nearly enough of that yet, but it is wonderful that within organizations such as the IEEE, there is this move, to develop standards, processes. So I mentioned this, which is a Five Rights document, but worked on also with the IEEE. So there are tools, there are frameworks, there are hopefully increasingly, and this is something at Five Rights we want to work on more with the IEEE, educational programs for engineers, because we do believe that most of the people working in this area, they do want to do the right thing. But the reality is, in terms of name and shame, I think it was last year that in the US, in Congress, that you had all of the bereaved parents who came and confronted the heads of the tech companies with their children who had died, and they all turned around and said sorry. And then the next day, Meta announced its share prices, and their stocks went through the roof. So these things, unfortunately, are not quite working, these mechanisms at the moment. So I think, I personally very much agree with you that that's where we need to get. But I think, indeed, enforcement at the moment is the first piece of the puzzle while we work on the rest. Or that is my view, but I'm going to ask Yanis for his view as the regulator, which might be slightly different. So as we heard, Yanis, keeping up is difficult. It's not working so well so far, and it's going to get even more challenging as AI advances. So what do you think as a regulator? Are we better off focusing on, in this case, really maybe simpler, clear-cut solutions like keeping children off the internet? We've heard a lot about bans recently. And then maybe we just leave the rest to self-correct in time with education, moral responsibility, digital literacy. Is this maybe the way we should go?
Well, thank you very much, Leander, first of all, for inviting me here and for asking this question. Let me start by saying that I'm mostly on the policy-making perspective and less on the regulator perspective, but in any case, this is a very pertinent question. To attempt to give a short and rather contrarian answer to your question, yes, this could be a necessary first step, but obviously nothing is as simple and clear-cut as I make it out to be. So let's try to dive in a bit into the details. There is a deep asymmetry in the relationship between public authorities and big tech. This has been documented extensively. Public authority, by its very nature, deliberately moves slowly and deterministically, meaning that it follows the principle of legality. This means that public authority can only do especially on continental systems, let's say, of public authority, it can only do what is expressly provided for in law, and it moves in a very preset way with little to no wiggle room. On the other hand, naturally, technological developments are coming exponentially faster with each year, which makes the job of regulators catching up with what big tech releases every other month extremely, extremely difficult. So, in this environment, making the regulatory framework more and more complex by, let's say, trying to find the exact perfect formula which might lead to the best result with categories and subcategories and subcategories of cases runs the risk of having the appearance of action while not leading to much real world change. To try to get back to children's rights online, obviously trying to find the exact correct formula for age-appropriate design principles to be implemented into the digital environment is of crucial importance. This is a noble work that actually will lead, as the title of the panel suggests, to a better internet for all. Because, for example, if we try to, because most of the risks that children face online are also shared by adults. Therefore, if we try to make the digital environment more friendly for children, this will lead to a more friendly digital environment for adults as well. And to double down on this point, keeping children off the internet, for example, Leander used the word ban, which is a heavy word, but keeping children off the internet completely is impossible. It cannot be done. However, we can find cross-cutting, let's say, lateral ways to protect children, such as mandating strict age verification for social media platforms, and maybe even installing an age of digital majority, under which minors will need parental consent to use social media platforms. Just a bit on the policy front on this issue. The Greek government has launched its national strategy for the protection of minors online from internet addiction, and this strategy calls both for strict age verification and an age of digital majority. I am aware that in France there's a law mandating digital majority, which has not yet been enforced for compliance reasons with the framework installed by the Digital Services Act. Digital Services Act famously does not contain an age limit for access to any sort of digital services. And a recent non-paper, which was circulated by Greece to all member states of the European Union ahead of the next Council meeting in June, which was co-signed by France and Spain, contains these two measures as well. Again, strict age verification and digital majority. Of course, these measures, again, they are not the be-all, end-all solution. They cannot be the end of the story. This is just impossible. But they appear a bit easier for regulators to effectively oversee and enforce than an overly complex network of overlapping standards, norms, soft law, self-regulation, etc. If I can be allowed a comment, actually, even the notion of self-regulation is a bit of a misnomer. In fact, for the best case scenario, it's the price is giving to social pressure. And I'm sure Felix can back me up on this, knowing that the work that NOIB does on the issue of trying to push enterprises and to actually comply, it's easier to, it's not easier, but let's say it's very difficult to see why an enterprise would voluntarily diminish its profits and the shareholder value in order to protect any sort of consumer. An enterprise is a profit-based structure, so it is natural that they would like to increase to maximize their profits. And again, to try to circle back to the initial question, obviously, age verification and digital majority is not the be-all, end-all solution. However, it is a necessary first step, which from a regulator's perspective appears to be easier to enforce. And allow me to conclude by saying that the European Commission has launched a tender for an age verification solution and white label application for an age verification solution to be used online, and which, therefore, this shows, I understand there are some technical issues with the age verification solution. I'm not sure that is entirely feasible, but it shows that it's a proof of concept. It shows that at the very least there is something that can be done on this front, and actually enforcing to see if social media platforms or any sort of platform actually incorporates this solution into their working or not appears to be easier than trying to have an overly complex network of overlapping standards, trying to enforce this, because this could lead very well to years-long legal battles, which, and in this case, and like in this instance, time works in the benefit of, does not work in the benefit of children or consumers. It works in the benefit of those keeping the, let's say, not age-appropriate mechanisms in place.
Thank you, Yanis. I think, this is also a reflection of the kind of crisis that we're in at the moment, that we're like, we need simple things to start with that hopefully can mitigate and, deal with at least a little bit of the issue that we have now while we maybe work out the longer term. I think, the reality in terms of something like digital age of consent is that we have under GDPR digital majority, but digital, you have to have parental consent normally under 13 or under 15 or 16, depending on the country. But that hasn't really had any impact whatsoever. I could do that poll again and ask all the parents in the room whether they consent every time their child uses a website, or I don't, so I don't know how this works. I think of course, if it were better enforced, then maybe having better age assurance systems would help. But we get back again to the point that it's, as you said, not the silver bullet, and we still need to work on the rest. So working on the rest, let's move forward to look at what we have maybe on the table now. Lynn, I'm going to come back to you, I think. So you were talking at the beginning about all of the, those 10 just in Norway, different laws that specifically, apply here. Well, and we talked about GDPR, and now, of course, we have more. Yippee! Problem if we're talking about complexity, but we'll come back to that at the end. I think maybe there is a question of getting things right and then slimming down. But anyway, we have the DSA, and in particular, as I mentioned at the beginning, we now have the guidelines on Article 28, which of course are not finalised and fully implemented and ready to be enforced yet. But what's on the table is looks probably quite good. Do you think this is going to raise the bar?
It's a good question. If I may, I want to start maybe somewhere a little bit different. I wanted to just mention, maybe following up on what was said here about age verification and that being like a feasible first solution. I think that we need to also see it in the light that, age verification introduces a lot of new risks for children. Actually, social media are a core platform that children and adults alike are it's necessary to be on these platforms today because we've allowed it to become a core service in our societies. And so I think it is a little bit too easy to say that we should start by getting children off of them and start by introducing these often very risky age verification solutions. And indeed, there are technical issues with trying to implement this in a rights-respecting way. And often when people introduce this measure, they say, well, we'll find a solution to that. And I think that is also a little bit too easy. I would love to see a solution that does indeed protect all of our fundamental rights before we roll it out and then we see what happens afterwards. So that was just a mention. I know I'm not going to derail this into an age verification discussion, but I just wanted to mention it since it was brought up here. And then coming back to it's also relevant for the guidelines. The first section of the guidelines is actually on age verification, so I think it's worth keeping in mind also when reading the guidelines. And then there's also lots of great things in the guidelines about how we need to design services in ways that will protect children. It goes very much in line and is a good addition, I think, to the GDPR, the Unfair Commercial Practices Directive, that will give us holistic protections for children. But as I think many of the speakers here have already mentioned, guidelines is a difficult tool to try to stop big technology companies from making a profit in a way. I'm sorry for this, I'm going to try to keep my distance. Guidelines is a very difficult tool to try to use to keep technology companies from making a profit off of children. Because as I said in the beginning, the design choices that we have online today, they're not it's not like a mistake that children are getting put at risk on these services. That is an inherent and very interconnected way that children are being put at risk because that is how companies are making a profit. So I think we need to keep that in mind. It's not going to be easy to make them change, and we know that. And NGOs have been giving big tech companies ways to have ethical services for 10, 15 years, and they don't care. They know that their services are risky and harmful for children. TikTok has, they have their speaking points about these screen time features that they introduced. They know that they do not work, and still they use them as speaking points to talk to politicians, to talk to all of us and say, we're super keen to protect children, and that is simply not true. So we do need to have enforcement, and that is going to be kind of where I land my fury speech here. But we do need to have enforcement that is actually deterrent, and that is, I think all of us have been talking about this. We need deterrent enforcement, and that is about fines, which is often what we're talking about, but that is also about saying, if you do not respect children's fundamental rights, you are not allowed to process their personal data at all. So we do need to target some of the parts of these companies' business models that will actually hurt, so that they will see that this is not just a cost of doing business. It's not okay. So that is the end of my first speech.
Thank you. I do wish now that we also had the Commission on the panel here to answer that. How are you going to use the DSA as a deterrent, right? So it is, the whole point of this is designed to change those business models. I know that all of us are a bit skeptical, unsurprisingly, but that is the point. It is supposed to be getting at, that commercial access, that the profiling, the persuasive design, the addictive design. We have the language of rights in there. So, and I do think it's a question of political will. So on that, I'm going to come back to Janis on that issue of political will and how can we ensure as well at the national level, because the DSA in Article 28 in particular is not in the remit first and foremost of the Commission, aside then for the VLOPs. And a lot of the work here will need to be done also by national authorities. So what can we do to ensure and support national authorities in this role?
Well, thank you for the question. You're right that Article 28 of the DSA is primarily, let's say, in principle enforced by national digital services coordinators. But, and this is a very big but, given that most issues arising, especially addiction-related issues, internet addiction-related issues, for children arise through the use of platforms that have been characterized as VLOPs or VLOCs, it follows that the primary role in trying to, let's say, combat big tech's attempts, let's not say attempts, big tech's mechanisms that do not comply with children protection standards falls principally with the Commission. We've heard about the GDPR. Indeed, under the GDPR regime, enforcement lies exclusively with national data protection authorities. They are tasked with overseeing and guaranteeing that the GDPR applies effectively within their jurisdiction. The DSA follows a different approach. While member states designate DSCs, and their role is to enforce the DSA on digital services, intermediary digital service providers, which are based in their jurisdiction, there's a preclusion of enforcement except in extraordinary circumstances of VLOPs and VLOCs. And enforcement of all articles of the DSA concerning VLOPs and VLOCs is reserved to the Commission. And let us not forget that the EU Commission has a quite persuasive claim to being the most well-financed and well-staffed public authority in the world. Therefore, I think it is quite natural that the Digital Services Act reserves this, let's say, exclusive jurisdiction for the European Commission. And also, the Digital Services Act allows the European Commission to have a very big wiggle room concerning what measures to dictate to platforms when enforcing the provisions regarding risk assessment and mitigating measures. There's a very long list of possible mitigating measures in the DSA, which include issues such as age verification and age-appropriate design for children. And again, this list is not even exhaustive. The Commission can still have other measures that it can designate. And it is the Commission that's the entity liable to primarily and effectively guarantee children's rights in the digital world. You mentioned political will, and the Commission, apart from being, let's say, a civil service, also is a political instrument, and it is up to the Commission and, to a lesser extent, of course, member states trying to push the Commission towards the direction that their policy priorities dictate. But it is up to the Commission to have the political will to effectively enforce both Article 28 and the articles concerning risk assessment and mitigation measures on the platforms that are mostly harmful to children's well-being. And if I am allowed a personal comment, I have seen that the Commission has demonstrated quite substantial political will when it comes to, at least in the very initial phases of enforcing the DSA, for example, with the designation of developers and velocities, and the demand for some provisionary measures even before the designation, the official designation procedure of some platforms as developers and velocities. So I think the political will is there, and what we must do, especially as national policymakers, is to make sure that this, let's say, rare consensus among EU institutions and national governments on the need to provide for children in the digital world does not go away.
Thank you, Yanis. I think, in today's geopolitical environment, we definitely need to repeat that message that, that should not go away. And indeed, we're seeing that political will. And I think, if we see that political will from all the member states, in addition to the Commission and Greece, who we know have been demonstrating a lot of political will on this, and we're very grateful for that. And hopefully all the other member states will, ensure that it stays that way. So thank you. Thank you so much for that, and we will be indeed watching the Commission, which indeed has additional powers, and also enforcing on big tech, as you say. I think first of all, not small tech is not safe tech, right? So it should not be a free pass for everyone. But it's true that a certain number of companies really do set the example in this area. So when they bring out a new feature or functionality, everyone copies, and also if they take it away, everyone copies. So it is about having a level playing field. And working a bit strategically, the bigger companies, as say, they do very much set the example for others. Ali, I'm going to come back to you on this. So, when we're talking about effective implementation, there is, of course, this issue of political will and the Commission and the member states, enforcing. And Yanis has just said how, the Commission has a lot of resources. But of course, as you said at the beginning, it really is about a much, much broader range of stakeholders. So what do we need, to get this down to the practical level? I'd like to ask you in particular about the role of also technical standards. What do you think would be the added value of having a European norm, a technical standard on age-appropriate design for implementation here? And if there are other areas of technical standards, how can we ensure that children are prioritized in the broader work?
Thank you. I fundamentally believe that the laws are essential for a fair and just society. There is no challenge there. There is no surprises in the necessity for laws, and then laws have to be enforced. The problem is laws like rules of ethics are fairly aspirational and lack the technical language and so-called API, or the interface with the technical world, engineering, metricated processes, etc. So we do need a translation mechanism between the laws that are judged and enforced by the legal system and the technical operators, designers, developers, maintainers of main technologies, specifically artificial intelligence technologies. And this is where the standards as an interface between the aspirational aspect or fair and just aims of a legal framework and rules such as DSA or AI Act and the actual practicalities of designing, developing a product or a service through a fairly complex set of processes, often referred to as a life cycle. Indeed, the 5 Rights AI Guide for Children did approach the guidance on the life cycle basis. Most technical standards actually do approach the processes of design, conceiving, designing, developing, proving, deploying, and then using and decommissioning products and services in a similar manner. They follow a life cycle model. They put normative contents on various stages of life cycle. And frankly, when we started developing, if you like, the first ethical guidelines for use of autonomous systems such as AI in products and services, IEEE 7000 standard, which was completed after a massive duration, about 5 years of deliberation and effort in 2021, we faced similar kind of challenges. How detailed and how precise had the normative requirements of this standard had to be. So if you consider the law at the apex of if you like, legal social order. And then we have these standards as an interim translation mechanism between the expectations or outcome-driven laws and exactly the instructional dimension for technocrats, designers, developers who do not understand the law, and probably the laws are not exactly communicated with them in terms of even intent. So they sit in a different paradigm, different universe. So frankly, there is no escape that these need to be translated into the language of technology to speak the same language, and then there would be more precision, more comprehension, and less leeway for these corporations to say, well, we have fulfilled our obligations, we have conducted risk assessment, we have specific smart criteria which actually can be checked and verified rather than fought, as cases were highlighted earlier, for a few years in a court without a conclusion. So this is where I believe the standards and, for example, in the context of children and age-appropriate services, I had again the pleasure and honor of working with the 5 Rights Foundation on IEEE 2089, which is talking about the digital services, age-appropriate digital services using the 5 Rights principles. These are giving a specific and measurable, practical, enforceable sort of guidelines and expected evidence for fulfilling and conformity assessment. So there are far less, if you like, uncertainties in the expectations of the standards versus the expectations of a higher order legal mandate under a particular law. So in short, we want to protect children and the vulnerable groups, and I have every sympathy with that, and I have been promoting this myself in my work. We really need to be able to use the metrics and the guidelines that are readily measurable, scientifically provable, rather than argued on merit and intent in a court of law. And this is where, for example, the AI Act is being supported by a whole gamut of standards being currently produced by Senelec under a mandate from the Commission, because these technical standards actually help proper implementation and conformity assessment for fulfilling the aspirations of the law. So in these technical implementations, we can then put the specific normative requirements on what expectations there are for a specific group at risk, such as children, and then they would be verifiable and validated. And there are sort of authorities in Europe that have the competencies and the resources also to check the conformity with the laws, with the technical standards. One problem with standards is that there are obviously voluntary instruments unless they are referenced by a legal system such as a contract or a law. So they could potentially be voluntary instruments, ethical adoption by industry, because there is less trust in that. Then they can be specifically referenced, and we've got many examples in the interoperability, for example, regulations in Europe, where specific standards are referenced, so they become mandatory. And conformity and fulfilling the normative expectations of technical guidelines and metrics are then enforceable and need certification. And frankly, these standards facilitate much fairer and level playing field for all suppliers internationally, because the rules are written in a very specific, understandable and enforceable language. That's where I would put the gap filler between the challenges of enforcement, dynamics of technology changes, but standards have their own problems. They take far too long to produce, like regulations, and we need to be moving to a new paradigm for agile specification. There are major, very promising developments in that direction as well.
Thank you so much, Ali. I think indeed, that's where we need to get, where the whole community of stakeholders has something they can use, so that the whole system is changed. But you mentioned those standardization processes. Of course, one of the challenges is we make the law based on the social outcomes that we want to see. But then when they go to not the IEEE is very democratic, but CENELAC has been having certain issues with the industry representation. So, when you want to do that translation, you have to keep quite a close eye on what happens there. So I think with that, I know we're running out of time, unfortunately. We could talk for much longer, but I'm going to do a last round, and I'm going to start with Felix, and ask you to come back a little bit on, this issue of political will and, industry power. And I think, we talked a little bit about the current political environment, which is quite volatile, and there's this whole pressure between growth and jobs and the social outcomes that we want to see. So what where do we go from here? How do we ensure this political will, and what are your also conclusions and priorities for going forward?
Yeah, thank you for this hard political question, actually. I will try to be brief and mindful of time. I don't believe there's a trade-off between, for example, growth, jobs, and enforcement and protection of children. I don't think there's a trade-off. Of course, we have been here at the conference as well and heard deregulation. That's kind of the thing that everyone is talking about these days. But let us remind ourselves for a second what regulation stands for. It stands for standards and good practices, and which in turn should benefit us as a society in the long run. For any society, it's paramount to have good regulation. It's not necessarily about more or less regulation. It's about good regulation. And now, just as an example, think about food safety. I don't think there's a discussion that we need certain standards for food safety. But anyway, so deregulation of tech, and which basically means watering down tech regulations, is very popular these days. I don't think it's a good way going forward, as it creates more or less a legal Wild West, because in an era where there's already a lack of enforcement and where there's very powerful more or less monopolistic players like Meta, Google, or Amazon, I don't think we need less regulation. Maybe we need better regulation, or we need more enforcement. And as a proof, more or less, of this, I just wanted to talk to you briefly about the state of things in the US. We can see how the state of things in the US is and why this is a good example of not adopting deregulation. So I just want to quickly quote an email I received recently, because I was kind of expecting this question, and I thought this email really hit the nail on the head. And basically it reads, without effective regulation, you get oligarchy and ultimately catastrophic failure. The rise of Trump is a failure of regulation, of social networks, and political donations by the morbidly wealthy. So is the country's precarious, potentially collapsing economy. The EU should not go down the US path, because while that path promises, and indeed in the short term may produce economic gains, it ultimately results in great economic damage, not to mention even greater societal damage. And this is a great example why regulation matters. And of course, enforcing the law is a part of any regulation. So now there's just the question left on how do we make sure that there's political will to enforce regulations. And of course, one could say a bit sarcastically, by voting for the correct politicians maybe, or by showcasing why enforcement is beneficial, for example, in the long run. If we reduce radicalization on TikTok, for example, that's beneficial for all of us, I guess. And also in the realm of tech regulation, strengthening the independence of supervisory authorities is a good thing as well. And then I think conducting studies, for example, about online behavior, children's online behavior, helps as well, because it provides for evidence-based decision-making. And I guess that's it.
Thank you, Felix. Yanis, I'm going to turn to you next. I think Ali has made a clear case for the fact that in a world of AI, we need a whole panoply of measures in this approach, and probably also constant monitoring, vigilance, review. How are we going to make this happen? Can our governance systems deliver that, or do you think something else is needed? And do you have any other conclusions for us?
Well, I think that you need a panoply of ways to tackle any sort of issue in today's digital environment, because it is very complex and has many different stakeholders, from the consumers, which may be divided into many different subgroups, for example, children, but not just an age divide. There are also other divides in the consumer base of digital services, to national governments, independent authorities that are tasked with enforcing different rules like DPAs or DSCs, EU institutions, also EU institutions among themselves as well have some differences of opinion. For example, the Commission or the Council of the EU may have different opinions on issues of big tech. And also different companies, the providers of the digital services. Many of them are based in the United States, but not exclusively. TikTok is based in China, for example, and they obviously have different interests among themselves. So in this complex environment, a panoply of different ways to address is necessary for everything. And in that regard, I really liked the the quote from Ali that standardization and norms, as well as the admirable work of the Five Rights Foundation, can work as a translation mechanism between the political will that is expressed in legislative acts like the DSA or the GDPR, or any national, for example, law that might tackle these issues, and the technical actual implementation, because it's very easy as a policymaker and as a lawyer to get caught up in discussions of merits and discussions of general interest, especially if you subscribe to more, let's say, French notions of intérêt général, etc., of how a society should be run, and lose sight of how you could enforce such issues on the technical level. And if I could be allowed to have one final word on the topic and one final quote, it would be that in that regard, success lies in ambition. I know that European governance has this reputation for being slow and unwieldy, but again, as I said previously, it is excellently staffed and excellently financed. If the political will is there, it can be done. It has been shown that maybe it can work. Also, by utilizing the aforementioned translation mechanisms between legal acts and the technical world, we can assure that this actually remains enforced prior to legal enforcement, and actually it is applied prior without the need to end up in years-long court procedures before national and European jurisdictions. And success, therefore, lies in ambition, and it also lies in tenacity. Let us not lose sight of the fact that this political will that has been demonstrated in the last couple of years on the issues of children's rights must not be lost. Otherwise, without any political will, no law can be enforced and no standard can take place and be effectively applied.
Thank you so much. Excellently put. I think we have a bit of our conclusion just there, so I won't need to repeat it, which is really good. But Lynn, I'm going to give the last words to you, and I'm so sorry we don't have much time for questions, although those who want to stay, really, really welcome, but maybe we'll manage one or two very quickly. Lynn, what are your final words? And also, I know we could talk about DFA and everything going forward, but what would you like to say to finish?
So there's so many things that I would like to say, of course, as we all do, but I'm just going to mention DFA briefly. Obviously, there are some gaps in the protections that we have still. Even though we have 10 laws, we still need to have, fill some of the gaps that we see, and some of them are on gaming, for instance. We've done a lot of work on gaming, and we really need to go into that market and get rid of some stuff. I wanted to mention influencer marketing and surveillance-based advertising, which is something that we've been working for years on, which is at the core of many of the issues that we see online today. So I just wanted to mention those briefly, and we have other measures as well. I took the liberty of leaving a report over there, so if you're interested, you can see after. And then if I may, I just wanted to add a point as well, because I think ambition is really good, something that we should strive for, because we do have this fantastic technology that is internet, and it can be used for all of these great things for children. They can connect, they can play, they can learn, grow. There's all of these things that they can do, and then big tech has essentially captured it and said, okay, you're going to have to do what we want you to do. You're going to have to spend all of your time there. We want to feed you all of this terrible content, and it doesn't really have to be that way. So one of the venues that we're really hopeful about going forward is also to focus on how we can foster alternatives, not only focus on how to make big tech a little bit worse, which is what we've been doing for years. We have 2 complaints against Google for essentially the same thing, 4 years apart. So they keep just tweaking it a little bit, and it's not, we need to be ambitious, I think. So what we would really like to see is to have, for instance, public sector funding, foundations as well, funding open source alternative solutions that are decentralized, cannot be captured by venture capitalists as soon as they have enough users. So that is really what we want to see going forward as well, on top of everything else.
Thank you so much. We're going to take just a couple of questions. Please raise your hand, and Manon will. We're going to take them together. Actually, if they're short, very, very short questions, comments, we won't have much time for answers, but at least if we know your questions, we can talk afterwards. So if you have comments and things, even better. While you are doing that, so please, if there's none, that's fine. I would just say that what our takeaways will be is we're going to be continuing work on enforcement, right? So on the guidelines, implementation, technical standards. Anyone who wants to work on this, you can also join the technical standards groups, feel free. So technical standards, enforcement, and more legislative work going forward to address some of these gaps. So come find us if you'd like to work together. Please.
Hello. My name is Dimitra Camarino. I come from Queen Mary University in London.
Can you speak up?
Oh, can you hear me now?
Yeah, maybe they need to tweak the microphone. It is on, though. It is on.
Oh, okay. So my question is something you said at the beginning, actually, is about parental consent. If parents, I'm not a parent, so I don't know how it works, but I was thinking, instead of parental consent, is there some work, I suppose, in parental control? You mentioned in your introduction that average kids before the age of 10 encounter porn online. I thought that was shocking. I didn't know that. Can it be technically that parents control the environment, the links, the websites that children visit in the same way as employment, in employment context, work controls the applications and some of the websites that we can access. And if we, for some of them, we need admin control. Like, we cannot download whatever we want. We cannot access whatever we want.
Okay, while you see if there's any other questions, I'm going to take the liberty of answering that very briefly. Parental controls, yes, but ask any of the parents in the room right now. We have those controls. We're struggling. It's really, someone mentioned, I think, a real imbalance of power. They are designed, yes, to put the responsibility back on parents. And as Lynn mentioned regarding just TikTok, but there are others, they know they don't work. We know they don't work. Doesn't mean they shouldn't be there. Panoply of measures also means, tools for different people. Digital literacy is all very good, very well and good. Parental controls, all very well and good. Not enough. If the systems, really, really powerful systems are designed to undermine, your agency, your ability. 4 minutes, thank you. So yes, fine, but definitely not enough. Doesn't take the responsibility away from the providers to design their products and services better. Simone.
Yes, Simone van der Hof, Leiden University. I had one question, which was, because there was something mentioned about age of majority and parental consent. And I didn't really understand what the proposal was, and we know parental consent is not implemented now, or not effectively. It's actually very hard to implement, and by children it's being perceived as privacy invasive towards their parents, to which they have a right to privacy in relationship with their parents as well. And then maybe one comment on age assurance. So it was now a little bit conceived as something to ban children from certain places, or to exclude them from places, which I would like to change a little bit that narrative, because I think age assurance is important to keep them away, of course, from harmful experiences, but also it can be used to provide them with age-appropriate experiences. So we can also put a positive stance on it. And you can do that in an accessible and secure and privacy-preserving way. So I think that's really important to keep in mind. Having said that, I think we should also maybe shift the focus a bit, or include the focus on public values when it comes to age assurance. So we're focusing very much on the technicalities at the moment. And once it becomes part of an identity wallet, for instance, just an idea, this might also lead to identification creep and things like that. So I think there's a whole lot we need to discuss there as well, which doesn't just focus on children, but also on other uses of digital technologies, which was also part of this panel, of course.
Thanks, Simone. Couldn't agree more on the age-appropriate design. Age assurance has good uses. I'll let Yannis answer the question just on, is digital majority different from the digital age of consent? And if so, do you think it can be enforced differently?
Very, very briefly, the idea of digital majority is to force, it was first done in France in this law that, again, for the time being is not being enforced. It is the idea that children below a certain age, let's say 15, might need consent of one of their parents or guardians or whatever to access digital social media. And the idea is technically that this can be done through applications such that also do age verification as well. But this is a step further. It's not necessarily tied with age verification. You can have a mandatory age verification without having an age of digital majority. And you're right that when it comes to parental consent in the GDPR, it has not been substantially enforced. And the whole idea of digital majority is to try to force this on the providers of digital services. So for example, you say you have to verify the age. This is why you can actually tie it with digital majority, with the age verification, but again, this is not necessary. You have to verify the age of all of your users, and if you see that they fall below a certain age, let's say 15, then in order for you to be allowed to provide your services, you have to mandate parental consent or guardian consent in order to allow the services. Again, this goes a step further than age verification. And again, technically it has some issues, but again, as a policy idea, it's something that's being discussed.
Okay, thank you so much. I think we will remember success lies in ambition, and that also should mean ambition, to do the bigger piece, right? So if we have age assurance, if we have age of digital majority, if we have parental controls, etc., 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 success lies in the ambition to get really down, and that will require legislation, enforcement, technical standards. So let's all work together on that. Thank you so much for coming. And thank you to our panelists, obviously. Thank you, Ali.